Welcome to this video analysis of the landmark Supreme Court case, Chevron Holdings, Inc. versus the Commissioner of Internal Revenue, GR number 215159. This video will explore the factual background and the critical tax doctrines established regarding unutilized input VAT refunds. We begin with the factual background of the case, focusing on the corporate structure, operations, and the initial tax refunds claimed by Chevron Holdings. Chevron Holdings, Inc. is a regional operating headquarters, or ROHQ, licensed by the SEC. They provide administrative and technical support to international affiliates. In 2006, they operated under a dual tax status, where foreign service sales were zero-rated, and domestic service sales were taxed at 12%. Consequently, they filed for an input VAT refund for 2006. Following the Bureau of Internal Revenue's inaction, Chevron elevated their claim to the Court of Tax Appeals. While they sought a refund based on their zero-rated sales, the Court of Tax Appeals en banc granted only a partial, minimal refund, citing issues with dual foreign registration proof, substantiation of 2005 carryovers, and a mandatory offsetting rule. The legal dispute centered on three key questions. First, the qualifications for zero rating. Second, the requirement to substantiate prior carryovers. And third, the necessity of mandatory offsetting. To qualify for zero rating under Section 108, services must be performed in the Philippines for a non-resident foreign corporation, with payment received in foreign currency. The court affirmed that taxpayers must present both an SEC certificate of non-registration and foreign incorporation records, as well as bank certificates for inward remittances, to prove their status. Crucially, the Supreme Court ruled that an audit of historical carryovers is not required. The law only mandates that input tax claimed has not been applied against output tax. Taxpayers are not required to prove the validity of every historical carryover since their inception to claim a current period refund. The Supreme Court also struck down the mandatory offsetting rule. Crediting input taxes against output tax and applying for a refund are distinct alternative options at the taxpayer's discretion. There is no statutory requirement to first offset 0% input tax against 12% output tax before claiming a refund. This table summarizes the requisites for a VAT refund under Section 112A, as interpreted by the Supreme Court, highlighting the shift towards simplified compliance and the removal of unnecessary burdens like proof of historical excess. The financial impact of this decision was significant. The Supreme Court modified the previous ruling, awarding Chevron an increased refund of over 1.14 million pesos. This correction removed the requirements for forced offsetting and unproven prior carryover deductions. In practice, this ruling streamlines VAT claims, as taxpayers no longer need to audit their entire history. It confirms the ability to choose between offsetting and direct refunds, though it reiterates the importance of maintaining strict documentation for non-resident foreign status. Thank you for watching this summary of the Chevron case. This landmark decision provides essential clarity on tax administration and refund procedures in the Philippines. The following sources were used in the preparation of this video.